It's my pleasure to introduce our speaker for today, Judge Michael Key of Troup County Juvenile Court in LaGrange, Georgia. He is also the incoming president of the National Council of Family and Juvenile Court Judges, and throughout his distinguished career as a juvenile court judge has been active with both the National Council and the Georgia Council of Juvenile Court Judges. In my first full year of practice, I was very happy that one of the courts in which I spent much of my time was in Judge Key's court. I spent a lot of time observing court and watching what was going on and learning how things should be done. And so I'm very happy that I'm still working with him these few years later. Judge Key has been a juvenile court judge for over 20 years. In that time, as I said, he's worked on many projects with the National Council of Juvenile Court Judges, including leading Georgia's implementation of the Dependency Resource Guidelines by conducting judicial leadership workshops. He also helped develop the Georgia Model Courts Project in conjunction with a number of other entities and individuals. He has served as a council trustee for 5 years with the National Council, and as I said, he's our incoming president. Within the Georgia Council of Juvenile Court Judges, he has served in every office, including president, committee chair, and everything in between. So most of his work has been done around permanency planning and case planning and working on permanent outcomes for children, and will benefit from that expertise today. He has also been the liaison for the Georgia Institute of Continuing Judicial Education and has worked on the delinquency side with the Council of Juvenile Court Judges as well as the deprivation side. He does a lot of education for all folks involved with the juvenile court system. He educates attorneys as well as volunteers. He's done a lot of work with citizen panel review members and the statewide entity that runs that, as well as CASA volunteers and other people involved with the juvenile court. So he is always incredibly generous with his time and his expertise, and we're very fortunate that he is here with us today. He has consistently throughout his career been a constant and vocal advocate for children, and we are grateful for that. He is one of our own from Emory Law School. He's a graduate here. His undergraduate degree is from Troy State University. He also has an MBA from Auburn and a past distinguished service in the United States Air Force. So I welcome Judge Michael Key to talk to us today about making reasonable efforts through effective case planning. Thank you.
Thank you, Karen. It is such an honor to be invited to speak to you guys, and it's particularly an honor that this takes place at Emory. I'm very proud to be an Emory Law School graduate. I must say that in the 3 years I spent here, I was never really referred to as a scholar. So I guess 31 years later, I get to come back and be called one. I'm going to make this as interactive as I can today. It's a little difficult in this small of a room. A lot of times you will want to go to the microphones to ask questions or make statements, and I welcome that. From time to time, I may just ask a general question, and you guys can call out from where you are, and I'll repeat what needs to be repeated if that's okay, if that works that way. Case planning is one of my favorite things to talk about. It's one of the things I got involved in early in this process. Good deal. All right. If you have something you want to say at any time, I want this to be interactive, raise your hand, we'll get a microphone to you, okay? And from time to time, I'm probably going to spend a lot of time out here, although I feel like a talk show host or something. I don't have a monologue, but I'll be back here some and up there some, all right? Disclaimer. First place, I'm not really an expert. I'm just a guy with a PowerPoint presentation. You guys know a lot about this work as well, and I want you to share that knowledge with one another. There are no dumb statements, no dumb questions. You need to understand that I take an expansive view of judicial oversight. That does not fit every judge, but that's what I do. I've done it from the beginning of my career, and that position has been nurtured through my involvement with the National Court, the National Council over the last 21 years. You can't hang around the judges and the staff and the National Council without getting at least some bit of this expansive view of judicial oversight. Tell you a little bit about what that means to me. I believe it's the responsibility of the judge to fill voids in the system. Doesn't mean I'm going to be a case manager, doesn't mean I'm going to be a lawyer, but it's certainly my responsibility to see that those voids are filled. And absent some specific authority to the contrary, I will assume that I have not only the authority but the responsibility to fill those gaps. Specifically related to today's subject, I think I have the responsibility to ensure that we have good case plans, that the agency works the plan, and that the parents understand the plan and the consequences of failing to comply with the plan. One of the things that we do in our court, and we've done it for a long time, is we review case plans in court with all parties present and their lawyers present. It's important to make sure we have good case plans. One thing that I've discovered is that quality case plans go up because we have an opportunity to educate one another about case plans and about resources that other people might not be aware of. Also, when you know you have to face the judge about 45 days into the case, then you probably want to make sure that you have a better case plan that you can present to the judge. There's probably a few things worse in our practice than having TPRs generally, but it happens, and it's for the children's best interest. But the really bad part about that is to get to a TPR and find out that you've been operating for 9 months, 12 months, 36 months under a bad case plan, or the parents didn't really understand the case plan. And now you've got to make the decision whether or not to terminate parental rights or whether to start all over the case plan. We're going to talk about reasonable efforts. We're going to talk about effective case planning and visitation or family time. This is a lot of information to cover in a pretty short period of time. We're going to take 2 breaks during this time period. I have a timekeeper watching it flag me down because I get to talk and sometimes it's hard to turn me off. And this is what we're going to hit. And again, I want to do it in as much depth as we can given those time constraints. We're going to address the legal issues, give you some take-home items, and hopefully inspire you to do the good work that you're already doing. There's so much good work being done in Georgia. The fact that I am going to become president of National Council in July is not only a reflection of the work I've tried to do in this field, but it's a reflection of the great work that Georgia has done over the last 10 to 15 years at all levels. Now, I like to do something in each presentation that kind of focuses on the kids. And this is something that I put together. I went to the Children's Summit, I guess 3.5 years ago in Minneapolis. And this came to me on the airplane on the way back home. Their belongings in a bag, their hearts on a sleeve are tucked securely away. Their future is not their own, but held in the hands of those who do not know them. Their worlds asunder, insecurity and mistrust, their constant companions. They come to us looking for answers, for understanding, for hope, for resolution. What we give them will determine who they are and who they will forever be. Equally as important, what they become because of their having passed our way will define our lives and our place in history. We have chosen to intervene in the lives of these families as our work, or if some of you are volunteers, as your volunteer work. There's a responsibility that comes with that, and our handprints are all over these families for the good or for the bad. And we have to keep them as a primary focus in all that we do. Talk a little bit about state power. I mean, it's pretty awesome when you think about state power. We have the authority to come into a family that is existing the way they think they should exist in most cases, the way they understand they should exist, and disrupt that family, take children out of their homes, oftentimes without the opportunity to tell their parents bye, for the parents to make provisions for them. The power of the state is awesome, and that power can be used for good or it can be used for bad. What responsibility comes with that awesome state power? Somebody tell me that. What responsibility comes with the state power? We remove children from their homes or intervene in their lives at all. Ensure that they're safe. Call them out. What do we owe the children? Let's talk about the children. Besides being safe. Come on, guys. Know the facts.
Follow a standard. Follow a standard.
Follow the standard.
A standard.
A standard. Standards can float from jurisdiction to jurisdiction too, but make sure there's continuity in their medical care. Do no harm. Works for doctors should work for us. Integrity and compassion. I mean, all these are good things, but we do need to ensure that children are safe, and we need to ensure that they're nurtured, they're taken care of when they're in care, and that we get families back together as quickly as we can, safely, and when we can't do that, that we find some other alternative permanency option for the child and achieve that permanency. In Troup County, we have what we call an objective. It's the reason we come to work every day. And it's in 2 parts. And one is to ensure that every child is in care, that should be in care, is in care, but not a single child more. And the second part is to ensure that every child that is in care is in a safe, nurturing environment that is supportive of the permanency plan for the child. Those are the kinds of things that we owe these children. Now, part one, let's talk about reasonable efforts. I picked this up. I did some training did a presentation in Nebraska last fall. And this is a great statement about reasonable efforts to me. When children and families require assistance from the state, the health and safety of the child is a paramount concern. And reasonable efforts shall be made to provide such assistance in the least intrusive and least restrictive method consistent with the needs of the child, and to deliver such assistance as close to the home, community of the child, or family requiring assistance as possible. When we talk about least intrusive, we're talking about supporting families, not supplanting families. When we talk about the least restrictive, we're talking about to the extent possible when we work with these families to allow the children to be children and the families to be families. We talk about needs of the child. We focus on the needs of the children, meet the needs of the children during the entire time we're involved with them. And as is promoted with the Fostering Connections Act, then we try to do all this in the community so we can maintain the children's connections with their family, with their schools, with their churches, with their community. A good case plan is so critical to effective permanency for the child that the failure on the part of the agency to timely develop and implement a good case plan in and of itself constitutes a failure to make reasonable efforts to reunify the child with the family. Does anybody take issue with that? And when we talk about here, the word is to timely develop. We're going to talk about timeliness in a little while. You know, I still hear stories where case plans are being filed 60, 90, 120 days down the road. I hear cases where the panel is sitting for the first view and there's no court-ordered plan. And there's really no excuse for case plans not to be filed within 30 days and reviewed by the court. Occasionally in Troup County, we'll have them 33 days or 34 days, but you're not going to get much beyond that. And that's everyone's responsibility to make sure that happens. And we're going to talk about some of the ways to do that. But there's no excuse not to be in substantial compliance with the 30-day requirement. And you can't say that you're making reasonable efforts to reunite a family if you don't have a good case plan and if you're not moving timely. Okay? And we should all use the reasonable efforts requirement as a tool to ensure the timely delivery of appropriate services. That's the goal. It should not be used by judges to punish defects. It shouldn't be used by lawyers to embarrass defects. We should all use reasonable efforts as a tool to ensure timely delivery of services. That is all of our responsibility. When compared to the human and monetary cost of bad case plans, good case plans are really cheap. No matter how much time you have to invest in them up front, no matter how hard you have to work on them up front, they are cheap when we compare that to the alternative. And things that we talk about in case plans, we're going to talk about this a little bit later, we see in case plans a lot that they're putting in the case plan to do something a week from now or 2 weeks from now that could be done before we even write up the case plan or while we're writing up the case plan. There's no reason for delay. And it's everybody's business. The agency, the judge, court staff, parents, attorneys, the child's attorney, CASA, service providers, foster parents. I made a presentation to foster parents on case planning a couple of weeks ago, and if you don't think they think it's their business, you should go to Jekyll Island with me next year if I do it again, because they think it's their business. And they had a lot of questions about it, and they were very excited about the presentation. The first time I was asked to do it, I wondered why to foster parents, but they'll tell you why. A lot of parents' attorneys here, right? And children's attorneys. Okay, good. I want to speak specifically to attorneys just a minute. I practiced for 10 years in the juvenile court in Troup County before I became the judge. So I've really been doing this 31 years. And I wish I'd known then what I know now. I know I could have done a better job back then. A lot of parents, attorneys I talk to, and children's attorneys I talk to, do not think that they have any stake in the case plan, that it's somehow not their responsibility to be involved in the case plan. And I will submit to you that it very much is your responsibility. What's the goal of most parents in the cases that we all are involved in? Get their kids back, all right? To get their kids back. And you need a strategy for that, right? Just like in a criminal case, a death penalty case, let's say. Then you got to have a strategy to get your client acquitted. That's your goal. if you handle a big personal injury case, if you're fortunate enough to get one of those big old personal injury cases, then your client's goal is to get a big check when all is said and done. You develop a strategy to do that, right? You would never let the insurance defense lawyer or the adjuster strategize your case for you. You would never let the prosecuting officer or a district attorney strategize your criminal case for you. And when the case plan is the strategy for getting the children back home. And you can be part of determining what that looks like, or you can sit on the sidelines and let somebody else do it for you. But you do very much have a stake in the development of the case plan, the implementation of the case plan, both in terms of making sure your client does what he or she should do and making sure the agency does what it should do and the other players involved in the process, including making sure courts do their work timely. Passivity equals complicity. What I mean by this is that we do all have a stake in the case plan, and we need to support one another in the development and implementation of the case plan. And I'm probably as hard on DFACs as anybody. If my folks were here, they would tell you that, I'm sure. But there's a difference in holding the agency accountable and agency bashing, whatever agency we're talking about. And we need to hold one another accountable, but we have to support one another as well. And to sit on the sidelines and let us have bad case plans and case plans that are poorly implemented, that fail, makes all of us complicit in that failure. We share the successes and we share the failures. Timeliness of delivered services is also important. Front-end loading of services. Someone mentioned earlier we need to know the facts. Investigations, those things are important. We're going to talk in more detail about those later. But I suggested earlier, and I would say again, that the failure to timely deliver services in and of itself may constitute a failure to make reasonable efforts if the case plan is otherwise a good case plan. You can have a good case plan that you stretch over 12 months. It should be done in 3 months. That's not effective case planning. That's not effective implementation of case plans. And delaying hearings, reviews, and delivery of services is like foregoing prenatal care and worrying about the baby when it gets here. We just can't do that. Case planning, we're going to talk about in a few minutes, begins at case implementation, begins at intake, and continues throughout the life of the case. Timeliness is a relative term, and it is relative to the facts in each individual case. Right? These cases should be, the case plan should be case specific. Every case is different. The case plans need to recognize that. I was kind of on the ground floor when CPRS was developed, as now shines, and sometimes I curse the day that we put those default provisions in there because they tend to drive the development of case plans. When properly used, that's a great system, but that's not case planning. Picking a drop box is not case planning. The time frame for delivery and or completion of service is almost never 6 months. I mean, you guys are still seeing 6 months for completion of everything in your case plans. Not many of it. That's pretty good. It's pretty good. I still see it a lot. But when you think about the things that need to be done, almost none of that's really 6 months down the road. The 6-month myth comes in because you have to come see a judge every 6 months to review or a panel to review the case. And we'll make sure everything's done before we have to go in to be held accountable. But when we talk about steps, they need to be time specific. And they're almost never 6 months. Also, this notion about being drug-free for 6 months before you can get your children back, that being the law is a myth. That is not the law. The law says the judge may provide that the parents cannot get their children back until we've had 6 months of being drug-free. But it's not automatically 6 months. The judge has the authority of imposing that condition. But you see it all the time where the agency will say, and other people will say, that hey, you got to be drug-free for 6 months before you get your children back. That is not the law. That's a myth. Every case is different. All right, what is reasonable efforts? What do you guys think reasonable efforts are? Short answers you can call out and I'll repeat them. Long answers, about to get you the mic. What are reasonable efforts? What kind of things go into reasonable efforts? Giving parents every opportunity to succeed. I like that one. Some people would challenge that when you say every opportunity. because people want to impose limitations like resources. Right? What else? Doing the best you possibly can for that family. Did you read ahead in the outline? You said that you would want someone else to do for your family. We're going to talk in some detail about some of these things, but I love what you said, because that is my definition. My definition of reasonable efforts is doing for the families and children that we serve that which we would want others to do for us and our families if we found ourselves in like circumstance. Now, is that the legal definition? I've been challenged on it. It probably is an aspirational definition because we don't have totally unlimited resources. But I would suggest to you that not working hard to get close to that standard is not making reasonable efforts. Certainly providing the minimum standards is not making, the minimum services is not making reasonable efforts. But I would suggest that everyone should aspire to this definition of reasonable efforts. Doing for others what we'd want them to do for us and our families if we find ourselves in like circumstance. Now, the reasonable efforts are required to preserve and reunite families prior to the placement of the child into foster care, prevent or eliminate the need for removal of the child from the home, and to make it possible for the child to return safely to the child's home. We're going to be talking mostly about that last one today because we're talking about case planning, to make it possible for the child to return safely to the child's home. We're going to talk a little bit about concurrent planning and alternative plans, but this is our primary focus today. There are two tiers of reasonable efforts. Now, I would tell you that I made up these names about two tiers, but I didn't make up the rest of it. The rest of it really is the law. I just said it kind of a cute way, Tier 1 and Tier 2. We're all familiar with Tier 1 reasonable efforts. Those are those efforts that we're required by law to make in every individual case to reunite families, to avoid removal or to reunite families when we can. Those are individual case type things. But also, I mentioned shortage of resources a few minutes ago. We're really not allowed as a system to sit on the sidelines and say, well, we can't provide this services because it's not available. We have a specific legal requirement under federal law to develop resources, to track gaps in the system and provide services to fill those gaps. And simply saying that we don't have the funds for psychological is not making reasonable efforts, unless you can also show that you have made reasonable efforts to develop the resource. Does everybody understand that? Does that make sense? So the Tier 2 generally is a state plan requirement. But if because of your failure to develop those resources, the Tier 2 reasonable efforts, in this individual case you don't have that resource available, I would suggest to you, and I find in my court, that the agency's not made reasonable efforts to reunite that family. Two responsibilities: to provide the services you have and to fill gaps in the system. Anybody want to challenge that? Do we have any SAGs here? Oh, now or later? All right. These are some questions that need to be asked when we're attempting to reunify families. What are the circumstances or conditions causing the child to continue to be separated from her family? That's to say, what is the specific reason the child could not be adequately protected at home and the specific harm that may occur if the child's returned home? Now, we have reduced the number of children in care in Troup County from, our high number was 223 kids in care. We're a population of some 65,000. We had 223 kids in care about 4 years ago. January 1st of 2008, we had 150 kids in care. On December 31st this past year, 2 years later, we had 57 kids in care. 2 weeks ago, we had 53 kids in care. And we think that by July 1st, we're going to have 40 kids in care. And we also have Andy Barkley run our safety numbers for us. And our safety numbers are still good. So the best that we can determine in every way we know how, we're reducing those numbers and it's still ensuring the safety of our children. And one way we do that is because we really follow the law. And Michelle talked earlier about standards. Then the standard is one of safety. If children can be maintained in the home safely, they need to be at home. And we need to work with the families in their home, either through voluntary family preservation or court-ordered family preservation. And throughout the life of the case, we have to keep reminding ourselves of the reason we removed the child And what are the real risks to that child, the safety risk to that child if the child is returned home? What services are being offered to reduce the risk to an acceptable level? Are those services reasonably calculated to reduce the risk? And I kind of look at this as reverse case planning. If you have a case plan, you should ask yourself sometimes that if mom, and I say mom mostly because it's mostly moms that I deal with, if mom does everything I have on this case plan, in the end, will I feel comfortable sending these children home? And if not, you got a bad case plan. Or you got a wrong permanency goal, one or the other. So in developing your case plan, look at the end of the case plan and see if you're going to be satisfied with what you've asked mom to do. Are the services being offered in a timely, accessible, and culturally and developmentally appropriate manner? You know what I'm talking about there. Is we will send a mom who reads on a third grade level, has an IQ of 60 to a parenting class to sit with 40 other people and have somebody talk to them. That's not a good case plan. That's not developmentally appropriate for that parent. Are desired outcomes being achieved? What additional services could be offered to reunify the family? To the extent that there are such services, why are they not being offered? To the extent that such services are not available, has the agency made reasonable efforts to identify and develop such resources? That's the Tier 2 reasonable efforts question. Now, here are some examples of no reasonable efforts to reunify, and the failure to develop a case plan around court's finding is a cause of separation. And we see case plans a lot. I do, maybe you don't. I don't see them as much as I used to, but I see them, where we're asking mom to do things that have nothing to do with a safety risk in the home for that child. They're good things for mom. And while we've got mom, we need to do everything we can for mom. But in Shines, there's a second page called secondary goals. And that's where those things should be. They should not be on a reunification plan. If they don't relate directly to the reason the child's out of the home, they shouldn't be there. And the court makes that finding. We're going to talk about that in a few minutes. The court has the responsibility for making the finding at the 72-hour hearing, subject to change at subsequent hearings, as to the specific reasons the child can't be maintained safely at home. And everything should relate back to that. If you're not getting clear enough findings from your court, you need to talk to your court about it. Okay? I know my folks do. Failure to conduct proper assessments. Once we've identified a risk to the child, a safety risk to the child, then we've got to assess the situation, whether it's drug assessments, psychological evaluations, family violence assessments, whatever they might be. I put a plug in too, because I also, in one of my other things, I'm the chairman of the Georgia Commission on Family Violence, and I think we miss a lot of opportunities to deal with family violence. I don't think we really see it as often as it really exists in the homes. I almost never see family violence assessment in the case plan, even when we have family violence present. The failure to match services with needs, expecting too much out of parents too early in the case. Now, I still, from time to time, battle my local defects office. I have a great office. We got to do better, but I have a great local office. But I still fight them from time to time about holding mom's hand early in the case. Because at some point, we've got to make mom accountable, right? At some point, we've got to make sure that mom can make the medical appointments, that she can show up for counseling, that she can arrange transportation. But is that necessarily 10 days after we took a child away from her? Is it? Depends on the mama. Right. But we took mom's children away from her for a reason, because she wasn't tending to the business of caring for her children at an acceptable level and was placing her children at risk. And she may be impaired by mental health, by substance abuse. She may be dealing with a lot of mental health problems that arose out of domestic violence. There's a lot going on with mom. And we've taken her kids away, which could tend to suggest or promote a little depression, you think, maybe, right? And we expect mom to get her head screwed on right in 5 days and make appointments. And for the agency to throw parents out there early in the case is not making reasonable efforts. And this is my view. I told you I take a different view than some folks do of reasonable efforts. Does anybody want to speak to that? I take silence as total buy-in. So now I can say that I had, 57 people or whatever in the room at Emory Law School, brilliant people that all agreed with that concept. Failure to provide meaningful visitation. Now, you might question why we have a segment of visitation in a case planning presentation. But you really know why, don't you? Because research shows that Meaningful visitation between children and their parents promotes permanency for the children, promotes reunification. We're going to talk more about that in that piece of the presentation. And failure to develop Tier 2 resources. Failure to provide transportation. Now, I would assume that just because most of y'all live in Metro, I guess, and some of you have public transportation, maybe most of you have public transportation, I don't know. But just because it's available doesn't mean mom can access it, right? So when we have a case plan, transportation is one of the biggest issues we have in my county. LaGrange is kind of in the center of the county. It's the biggest, it's the county seat. And we have 2 other cities on each end of the county, West Point, where Kia's now made, and Hogansville. And within the city of LaGrange, we can't even get people to their services because transportation is a huge issue, much less out to West Point, Hogansville, and other parts of the county. And to say, well, they can call a taxi, which for $3 you can go anywhere within the city limits of LaGrange for $3 in a taxi, not counting the tip. They can't. If they call a taxi, they've got to call, if they can get anybody to come at all, if they're not a regular user of the taxis, they have to call hours in advance and plan to get picked up 2 hours in advance, just in case they're going to be running late, and they still might not show up at all because the taxi services have so many people stand them up that they don't regularly do business with. It's very difficult. Transportation is a huge issue. And failure to provide that transportation when there's no other option is a failure to make reasonable efforts. We'll talk about this later, but in case I forget to say it then, when we're reviewing a case plan, and if we know that mom has to get somewhere, and we should know, if we're a case manager, we should know whether or not mom's got a car, right? And we should kind of know mom's transportation abilities or inabilities. And we need to deal with it in the case plan if they can't get where they need to go. We have to include that in the case plan. Whose responsibility is it to provide transportation? Yes? Let's get the microphone back there for you on this one.
It's the Tier 2 development of resources. You're saying that you're not accepting just the response that the funding, there is no funding or there is no money. You're looking for a development of resources. Could you give me a specific, what question are you asking in that area to determine if they have or if they're able to develop resource?
That's a good question. The first time it came up in my court, which was a long time ago, it was a psychological. And I wanted a psychological on mom as part of the case plan. And I was told that they don't have the resources to do that. And I didn't accept that. And I asked the case manager, you know, where have you looked for resources? And of course, this is the case manager in court, and she's not responsible for developing resources. So we reset the hearing. And in this particular case, I might have overreacted. Then I subpoenaed the county director, child welfare director, and a general subpoena to anyone at the office that has check signing authority. Because in fairness to them now, they received money with limitations. And you got this pot of money and this pot of money. And sometimes you need a psychological, but for the particular type of case we got, that we have, we don't have any in this pot that's applicable to our case. There's some in this other pot, but they can't use it for this kind of case. I mean, I understand all that. I understand it. And my point is, I want to ask the questions. I want to make sure the discussion is taking place. Have we really looked for the resources? And in that particular case, we never had to have that hearing because they found the resources. And that's the question, is are you looking to find and develop the resources? Sometimes they can't be there. If they really can't be there in spite of the reasonable efforts to identify, locate them, develop them, then they have made reasonable efforts. It could be the same thing with transportation. When we talk about visitation, I tell you, transportation was a huge issue on visitation. And it would be a bigger issue today than it was then because of the budget cuts. And we had to deal with that. We had to provide good information to service providers, because what happens a lot of times is that we refer someone for psychological or for treatment, but we don't give them good information about what we're talking about. And if I'm lucky enough to get a report back from a therapist, what I'll find out is that they're providing some great services to mom. Have nothing to do with the reason the child can't return safely to the home. So we've got to give them good information. And if you don't do that so they can help solve the problem, you're not making reasonable efforts. Failure to follow up with service providers. And I'm not talking about the attendance reports. The mom made 8 out of the 12 appointments. That's not what I'm talking about. I'm talking about following up on a regular basis. Don't wait until mom has missed 3 appointments to find out she's not going. Stay on top of that. The failure to obtain meaningful reports from the service providers for hearings and reviews, and we talked about that. We have a great service provider protocol, and we're working on this second piece now. If a child now is removed from her home, then within 2 weeks from physical removal from the home, we have a psychological evaluation done on mom. With 7 days after that, we have at least the written recommendations, if not the full report. So that when we develop a 30-day case plan, we've got something to work with. Okay. That's good front-end loading. The second piece we're working on with them now is not just timeliness, but it's getting good reports back while we're in the case to see how people are doing. Failure to timely file revised case plans, evaluation, and other documentation necessary to conduct hearings. You get to a hearing or review, and you just don't have the information that you need to do your job. And if you're not getting that information, then you're not making reasonable efforts. The National Council has the resource guidelines on how to conduct abuse and neglect cases. In the back are checklists. So there's no real reason not to know what's going to be decided at the hearing. It's all set out in the checklist. So you should know what kind of information the judge expects you to bring to court. Failure to expedite child support proceedings. Now we can have a discussion about that, but in a lot of these cases, part of the reason mom can't maintain a safe and stable home for children is she has no money from dad. Juvenile courts have the authority to order child support, and we need to get child support, create that stream of income for mom that could be transferred then to, say, a relative or someone else if we have an alternative permanency plan. Failure to involve parents and others in case planning. You know, we see that a lot. We're going to talk in more detail about that in a minute. I'll get to it. Failure to communicate contents of a case plan. Failure to communicate, period, could be a failure to make reasonable efforts. The failure to identify and work with family strengths could be. Again, all these depends on individual circumstances. These are just bullets, and we make individual determinations in individual cases. The failure to meet the needs of the child. If we're not meeting the needs of the child, that can delay permanency, which is a failure to make reasonable efforts. Failure to be prepared for hearings and reviews. I mean, some folks think if you show up, whoever you are, whether you're the lawyer, the parents, or the agency, and you're not prepared, that you're just not prepared. That's a failure to make reasonable efforts. Every one of these steps is part of driving the case plan, and if you're not prepared to do your part in it, you're not making reasonable efforts. Failure to comply with ICPC. I want to talk about ICPC. Failure to comply with policy, standing orders, and protocols. Probably one of the most dangerous folks out there is a judge that knows a little bit about policy. Because if you fail to comply with your own policies, you're not making reasonable efforts. I don't think anybody can argue with that. If you have standing orders in place, particularly standing orders that are agreed upon as part of your stakeholder groups and protocols, you're not making reasonable efforts. And I would suggest that the failure to comply with best practices that you have put in place is a failure to make reasonable efforts. Now, some of your counties, if your agency did not have a psychological within 45 or 60 days, that's okay, because you don't have these things in place. In my county, since we work together to make them available, if you don't get that psychological within 2 weeks because you didn't schedule that psychological and take advantage of what we put in place, you're not making reasonable efforts. Because it's in place there to move these cases, to work the cases. If you skip that step and we delay permanency, that's not reasonable efforts. All right, alternative permanency plans, if continuation of reasonable efforts to reunify the family is determined to be inconsistent with the permanency plan for the child, reasonable efforts should be made to place the child in a timely manner in accordance with the permanency plan to complete whatever steps are necessary to finalize that permanent placement. That's the second piece of reasonable efforts. And most of these are sort of the same, except the failure to do concurrent planning. Really experienced case managers and other stakeholders in this process know early on whether we need a concurrent plan. That's never really rocket science. We really know it pretty much early on in the case. The failure to timely identify alternative placements and the failure to counsel a child on alternative placements is really important. You know, if you, as an example, if you have a child who is 14 and says, I just don't want to be adopted, and you accept that, or maybe the case manager says, oh, why don't you? Let's talk about it a little bit, and you have a little conversation about it. That's not making reasonable efforts at all. That child needs independent adoption counseling to understand from someone separate from the agency the advantages and disadvantages, short-term and long-term, to adoption. Now, you may not have that, but the failure to ask the question, the failure to try to develop the resource, is just not doing what you should do to move these cases and to serve these children, these families. And the failure to comply with the 1522 requirements, that still happens a lot as well. You guys are familiar with those. Other reasonable efforts issues, is the standard for a return home different at different stages of the case? What about that? Mom's a drug addict. She's a drug addict that impairs at some level her ability to care for her children. Now, is that the same thing with a 5-year-old as it is with a 15? Or not? I'm here mostly knows. Now, that's one way we reduced the number of kids in care, is we had some kids in care, been in care an embarrassingly long period of time. And I share responsibility for that. These are my kids. When we got to looking at it, we got a 17-year-old kid, and mom's still doing drugs. You know, not all the time. She's still doing drugs. It may impair her ability to care for a 5-year-old, but not necessarily the right kind of 17-year-old. And the other thing we recognize is when that child's 18, the child's going home anyway. So we can turn the switch at 18, let that child go home without any agency supervision or any outside resources. Or we can transition that child home with resources. And we made the decision that that's a more appropriate way to do it. A child can be safe at 15 that can't be safe at 5. Medical neglect being another example of that. 15-year-old's probably going to find a way to get somebody to take care of his medical needs, or maybe be in a better position to administer his own medicine than a 5-year-old. So it is different.
In the terms of drug use, do you make a distinction as to what drug they're using as to how you would apply this particular standard?
We do. We make a distinction, but we look at it in each individual case. And we just had this come up this week when the child was going home, mom kept telling me, I smoke marijuana every weekend. There's no way we could say that child was going to be impaired going home. Great child, very mature child for his age. Then I challenged her, well, why don't we do a drug test? Just to kind of see. I don't want to do a drug test. Well, she finally admitted she was actively using cocaine. It does make a difference in different situations. It depends on how frequent the cocaine use might be, how and to what extent it impairs her ability, the age and maturity of the child, other adults in the household. There are a lot of factors that come into play. So certainly it does call for more questions. Should the agency be required to hold the parent's hand? We talked about that early. Should the agency be required to file a motion for attachment for contempt before withdrawing services based on parents' failure to accept offered services? It's kind of the sledgehammer kind of deal. I don't know how many agencies use contempt, but my point is the question should always be asked before we go somewhere else and call mom a failure on a case plan. With filing a motion for attachment for contempt and holding mom accountable early on in the case plan for not accessing services, promote permanency. And if it would do it, if with this given mom, just the threat of spending 3 days in jail would make a difference, then we messed up by not doing that. We need to use contempt motions in appropriate cases. There's some cases, if we've got a mom who already has a criminal history, who's just going to jail is just a break for her, it's not going to have any effect. And in that case, the failure to do it probably does not constitute a failure to make reasonable efforts. It's the failure to ask the questions in each individual case that gets us into this no reasonable efforts box. And you have to document your findings. Right. Those are kind of the reasonable efforts. This may be a good time for a break, Michelle. Are we close enough for that, you think? Let's get questions on reasonable efforts then. I've talked more than I intended to because I'm afraid of time a little bit. But any questions or comments about reasonable efforts? Yes?
You mentioned more than once sending the parent for a psychological. Do you order a psychological for every parent in your court?
No, we do not. And actually, there's been a lot of discussion about the cost of the Child and Family Service. What is that thing called? That. Where you get those in every case. And you probably don't need them in every case. And that's one way to save money and not throw the whole thing out because we don't have enough money is to have a better way of identifying those cases where you do need them. I'm not an expert in this area. You could use mental health screenings first to determine who needs them and who doesn't. But we make individual determinations whether or not to order the psychologicals. Other questions, comments?
The only time-bound issue that I saw in any of the discussion was the 1522 rule. Where does reasonableness of giving the mom on the 8th child the same full basket of tricks. We use the expression, all reasonable efforts. Well, I think all reasonable efforts for the parent ends up punishing the child. And I find the balance sometimes being, well, we always have to do this. And it seems to me that we always have to take into account history. And if this is the 8th child, maybe we don't need to do everything we did for the other 7. Could you speak to that?
Yeah, and the law specifically deals with that when we talk about the exceptions to having to provide a reunification plan where mom has previously failed to comply with court-ordered plan for unification. And that's the point of ASFA, is that we don't have to always offer those services. There are circumstances where we know in the first 30 days of the case, this is not a reunification plan. We're going to talk a little bit more about that in detail in the effective case planning portion of this. But absolutely, we don't have to put every child out there with mom for 12 to 18 months before taking the child and TPRing the child, certainly if we've TPR'd other kids. Now, having said that, every case is individualized. Every case. And there probably are appropriate circumstances where mom has lost 3 or 4 children, either to TPR or she's placed them with relatives with or without agency action, and now she's got a child and she can care for this child. There are situations where mom can care for a child but can't care for 5 children. So every case is unique. We can't just say that because mom has failed 5 times before, up front, we're not going to give her a chance in this one. Every case has to be individualized. Yes?
In reference to your psychological evaluations, you indicate that you ordered that they be done within 2 weeks. How is it you all are able to get them done so quickly? Just to compare, I'm from Fulton, and it's 60 days or more.
Well, like all good collaboration, you bring folks together. National Council has a great book on collaboration, by the way. But what we did, a county director and I, had a meeting on a Tuesday night. We brought all the service, we're a county of 65,000. I can do things in Troup County you can't do in your counties, perhaps. You can do things I probably can't do. But we all need to try to find ways to do all the good stuff. We brought every service provider that provides the psychologicals in DFACS cases together that night, put them in the jury box in my courtroom. We talked to them about the time frames of ASFA. We talked to them about timeliness for kids and what it meant to kids. Educating them on the system and what an important role they played and how important it was. None of these guys and ladies knew that a case plan had to be developed in 30 days. They didn't know that. Nobody ever told them that. So we educated them, we asked for the commitment. In my court, we're an independent court, so we also have a delinquent staff. So it's been kind of a scramble to use those time slots, as a matter of fact, because we're bringing fewer kids into care. But we have a certain time period set aside by a psychologist who agreed to do it, that we contracted with. It had to be a psychologist who was acceptable, I hate to use that term, but whose evaluations were acceptable to both our deprivation teams and our delinquent teams. That time slot, it started Thursday afternoon, I think it's a Friday morning now, every other Friday morning, he has set aside to do these evaluations. Starting on the Monday before, then DFACS has first shot at that time frame. If we've had a child come into care within that week, the previous week, or that week coming in comes into care, they put that mom or dad into that time slot. If not, if they have a psychological that was not an emergency, it could have been a family preservation case, that was scheduled out 60 days, they slide that mom into that slot. If they can't fill that slot, we've always got some kids on the delinquent side we can slide into that slot. So we did it and guaranteed that service provider that somebody would be there to be evaluated. Because DFACS doesn't pay as much as most folks. Our court does not pay as much as private psychologicals. That's not the biggest issue with the providers I talk to. The biggest issue is no-shows. So we had to find a way to eliminate no-shows. So you need to bring your stakeholder group together and say, why can't we get them earlier? Identify the reasons, find solutions to those problems. Need to follow up?
I have a comment actually just about case planning.
Okay.
I'm a SAG in Cobb County, and one of the things that we do is when we have a 10-day hearing, I'd say about 75% of our cases are settled by agreement. But the judge won't accept just a stipulation about the circumstances of deprivation. As part of that agreement, we discuss what the case plan goals are going to be, and the parent then has an opportunity to discuss with their attorneys what the case plan goals are, and there's a buy-in. They have to agree, okay, these are the things that are going to be part of my case plan that are going to be a minimum requirement for me to do to get my child back, and that has to be part of the agreement. So the child leaves, or the parent leaves the courthouse knowing exactly what they're expected to do, and it's in the court order what they're expected to do.
And that's great work. That is great work. Because as I said earlier about case managers having a really good idea, experienced case managers knowing what needs to be done in certain cases, when we need a psychological, then with all those folks in the courtroom together, there's a lot of experience there. And you probably know, based on what's going on in that case, that some things are going to have to be done. There may be other things down the road, but you got a good idea of what needs to be done, and it's great not to wait until we have the assessments to start delivering services. Even at the 10-day hearing, if we know we have drugs as a problem, as an example, even before the assessment, then on a voluntary basis, if the case is continued, but if we make a disposition that day, then we order some drug intervention at some level until we can get the assessment. We don't wait. And in fact, under our Operation Home Team protocol, then we have what's called a service plan that's developed at intake that starts providing those services at intake. We also have the ability to get a drug assessment, not a drug screening, not an assessment, not a full assessment. We can get that done the first business day following the child coming into care, and get some indication of services needed, and we have that information available at the 72-hour hearing as well. All right? I think that takes care of the first portion. How long a break, Michelle, did you say?
10
10-minute
minutes.
break.
10 minutes.
Let's try to be back on time so we can stay on track.